Hello everyone. So let's continue from the last session's discussion. We have seen the offences and penalties part of both the concepts, payment of wages as well as the minimum wages. And there are some cases on both concepts of minimum wages as well as the payment of wages that we have to discuss in this session. So let's just start with the first case. The name of the case is Bank of India, Bombay and another versus T.S. Kalevala, Bombay and others. The citation and abbreviation of this case is in bracket 1988 IILLJ 264 BOM. Now in this case, Bank of India, Bombay and another versus T.S. Kalevala, Bombay and others, what happened is there were some bank employees who had demanded the revision of their salaries, who demanded the revision of their wages. And while this demand was pending, while they had made such demand, they decided to go on a strike, and this was a strike of 4 hours daily. So they started going on a strike of 4 hours daily, and after this, the bank issued a circular stating that the participants of this strike of 4 hours daily. Participants of this strike, will have to face the consequences, and the consequences would be the deduction of the wages of the full day for all those days when the employees are going on such strikes. So the strike was only for the 4 days, 4 hours in a day. So it was almost half day of the half working day that the employees had thought of going on a strike, and the employer, that is the Bank of India, Bombay, stated that we will be deducting the amount for the full day for all those employees who are going on the strike. Now this matter went to the Bombay High Court, and the Bombay High Court was of the opinion, or the Bombay High Court held, that the strikes and demonstrations are the legitimate forms of the protest, and these they are not banned in the country. And since it is not banned in the country, if it is if it's a legal strike wherein the 7 weeks or 10 weeks notice has been given, or 6 weeks notice has been given, whatever the case is, has been given by the employees to the employer, and if they have followed that, then in that case it won't be considered as an illegal strike, and such protest should not be considered as illegal, and any administrative circulars cannot stifle such legitimate mode of the protest. This is what was held by the Bombay High Court. And further, regarding the deduction of the wages, full day wages, the Bombay High Court stated that the deduction of the wages for the absence of duty, agreed that the provision provides that during the absence of the worker, wages can be deducted, but of course that moment there was a previous act which was existing, the Payment of Wages Act. So the Bombay High Court stated that the interpretation of the sections of the act provides that there should be the deduction should be only for the actual absence of the worker or the employee. That means if the employer is deducting the amount for the other hours when the employee has actually worked, it would be considered as unauthorized deduction, and that shall not be permissible. So the same was the view of the Bombay High Court, that the deduction for the working hours, or the hours when the employees have not gone on a strike, because the employees of the bank decided to go on a strike only for the 4 hours in a day. So the Bombay High Court stated that for remaining hours where the employees have actually worked, there cannot be any authorized deduction, and any deduction of the wages for those working part of the employees would be considered as a contravention of the provisions of the act, and would attract the punishments or the penalties whichever are mentioned in the act. So the Bombay High Court was of the opinion that in the case of absence from duty, the actual the deduction should be made only for the actual absence from the workplace or working from the working hours, and not for the full day. Next is the case named Surendranath Nair versus Nair and others versus Senior Divisional Personnel Officer. I'll repeat: Surendranath Nair and others versus Senior Divisional Personnel Officer. The equivalent citation and abbreviation for the same is in bracket 1988 IILJ 227 KER. This is a judgment of a Kerala High Court. What happened in this case is some of the railway employees had applied for casual leaves to participate in an agitation against the railway department or the railway administration, and of course the leaves were not granted because the CLs were applied with the reason that we would want to participate in the agitation against the railway administration, and hence the railway administration or the employers did not grant the CLs and had refused the leaves. And beyond this refusal, the employees whose leaves were so refused went on participating in the agitation, and on the action of the same action of this employees, the wages of such employees for those period were deducted by the railway administration, by stating that this is a deduction for the absence of duty or from duty. And it was held by the Kerala High Court that the rejection of a leave under such circumstances is legal and proper under the Railway Establishment Code. And as such, the absence from duty is rightly applied by the employer, because going against the management is unauthorized, and unauthorized absentees shall have no right to compel the payment of the wages for the period when they have not actually worked. So it was held by the Kerala High Court that the deduction of the wages of those employees whose leaves were refused were appropriate. So two things are there. One is the rejection of the CL was considered appropriate by the Kerala High Court as the rejection was in consensus with the Railway Establishment Code, because it was the reasons for the such casual leaves was that they wanted to go against the administration, and hence the leaves were rejected. And on such rejection, if any deductions are made for the absence of duty, it was held that it was an authorized deduction, and there shall not be any claims of the employees which can be sustained in this regard. Next is a question what if the strike is illegal, or so what happened in the case of Mineral Miners Union versus Kudremut Iron Ore Company Limited. Just write the citation and you'll find the case. The citation of this case is ILR 1988 KAR 2878. This is a judgment of course, Karnataka High Court. So what happened in this case is workers of an iron industry went on a strike which was illegal. So illegal strike without, we already know what is legal and illegal strike, right? We have already studied this in this Industrial Disputes Act. So the workers of a particular industry, iron industry, had gone on an illegal strike without giving a due notice. 6 weeks, within the 6 weeks they have to give a notice. So that notice was not submitted or was not given to the employer, and had gone on an illegal strike. And on such commission of or such participation of the employees or the workers in the illegal strike, the employer had deducted the wages of such employees, and it was held by the Karnataka High Court that deduction of the wages for the illegal strike is justified, because since the strike was not legal, the participation and absence from the duty, participation and absence from the duty can definitely or rightly bring in the deduction within the head of absence from duty. So if in case there is illegal strike, it would be considered as a valid deduction. There is one another case that we have to discuss, which is French Motor Car Company Limited Workers Union. French Motor Car Company Limited Workers Union versus French Motor Car Company Limited. The equivalent citation in abbreviation for the same is in bracket 1991 bracket over ILLJ 107 GAU. This is the judgment of Guwahati High Court. Now, what happened in this case is that there were few employees of this French Motor Car Company Limited who went on a strike, and they indulged into go slow practice and then a strike of 3 days for non-granting or for non-payment of the dearness allowances to them. So they made a claim that we should be paid dearness allowance, and if we are not paid dearness allowance by the employer, we'll go slow. They started working slowly during the working hours, and then they went for a strike for the 3 days. Now, of course, employer did not allow this 29 employees to go for such strike, and when they went for a strike, the employer stated that they have to sign a guarantee bond that they'll not be repeating such strikes in future. And the employer did not allow 29 employees to resume their work unless they signed the guarantee bond. And the employer also deducted the wages for those who went on a strike for 3 days and those who couldn't sign guarantee bond and did not work. So what happened here is employees went on a strike that we are not paid dearness allowance and we shall be paid dearness allowance. If we are not paid dearness allowance, we'll go slow, and then they went on a strike. Now when they were resuming from the strike, the employer made it compulsory for all the employees that they have to sign a guarantee bond that they'll not be going on, they'll not be doing certain actions during the course of their work. And while this was subsisting, the employer also stated that definitely the wages of those who had went on a strike would be deducted, and all those who will not be signing this guarantee bond, they cannot resume the work or resume at the workforce. So of course this employee went to the Guwahati High Court, and the Guwahati High Court had to determine 3 questions. One was whether the non-payment of dearness allowances or shall be considered as deduction from the wages. So it was held by the Guwahati High Court that of course dearness allowance doesn't form a part of the term wages, and hence it should not be considered as this thing deduction from the wages. And the second question was the deduction for the wages of 3 days for those who went on a strike. The Guwahati High Court held it valid. The Guwahati High Court stated that definitely if there is no work, there cannot be payment for the same. So no work, no pay policy shall subsist, and in accordance to the same, the authorities or the employer is justified in their action. And the third question was whether the deduction of the wages of the 29 employees who did not sign the guarantee bond was appropriate or not. So for this it was held that no, it was not a justified action of the employer, since the absence was not voluntary. The employer made it, compulsory for all the employees to sign a guarantee bond, and if they are not signing, they shall not resume at the workforce, and their wages would be deducted. So such absence were not voluntary from the side of the employees, and it was inflicted from the side of the employer. So here the employer was at fault, and it was not justified, or was not considered justified by the Guwahati High Court in this case. Now while looking at the first question or the issue, which is non-payment of dearness allowance, whether that forms a part of the wages or not. So that moment it was the Payment of Wages Act which was subsisting, or which had the jurisdiction to deal with such matters. So the definition of wages there was not including dearness allowance, or was not forming a part of the wage, and hence it was held that it is not a part of the wage. However, if you see the current definition of the wages, section 2y, it states that it includes basic pay, dearness allowance and retaining allowance, if any. Right. So in that case, it would be considered as inclusive of the wages. Again, if you read or interpret the definition says that, I'll repeat the definition in the section 2y of the Code on Wages of the term wage. It says that wages means all the remuneration, whether by way of salaries, allowances or otherwise, expressed in terms of money or capable of being so expressed, which would, if the terms of employment express or implied were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment, and includes basic pay, dearness allowance and retaining allowance, if any. So again, these three things, basic pay, dearness allowance and retaining allowance, is inclusive of, right? And it says that and includes, right? And then in the last it is mentioned, if any. So there could be, there could not be any dearness allowance or retaining allowance in case, and then in that case it may not be considered or may not be claimed as a matter of the right by the employees. So that's it for this session. In the next session again we shall discuss some more cases in the same line on the concept of wages and the concept, the different parts of, or the provisions of the code on wages. Thank you.